You're the one raising your child, and you have been there since day one. Or maybe you just found out that you're a parent. And now the hospital, the court, or someone else is saying that you need to establish paternity. But what does that really mean in Illinois? Is it as simple as signing a form, or do you need DNA tests? And what rights or risks come with that? I'm Jeff Hughes, lead attorney and CEO at Sterling Lawyers, and we have helped thousands of Illinois parents navigate parentage, custody, and child support, even in the most complex family law cases. In this video, I walk you through the exact ways you can establish paternity in Illinois and what's changed in 2025 and how to protect your role in your child's life. Now let's start with the most common path. Option 1 is voluntary acknowledgment of paternity, VAP. If you or the other parent agree, the fastest and easiest way to establish paternity is a voluntary acknowledgment of paternity, VAP. What is it? Well, it's a legal form that you both sign. Usually it's at the hospital that says, yes, this is the biological father. And once it is filed with the state, it is as powerful as a court order. But there is a catch. Signing a VAP makes you the legal father with full child support obligations, but zero parenting rights. No visitation, no decision making, not even a guarantee of seeing your child unless you will file for it separately. We have seen so many dads say, well, I signed the papers, I thought I had rights. But paternity is just step one. It is not the finish line. You can rescind a VAP, but only for 60 days. After that, you are locked in unless you go to court and prove fraud or mistake. Option 2 is presumed paternity. Illinois law actually presumes that someone is the father in a few situations. 1 is married to the mother at birth. 2 is the child was born 300 days after a marriage ended. 3, you married the mother after the birth and are on the birth certificate. And 4, you signed a VAP. But here's where things get tricky in the law. If someone else is the presumed parent, like an ex-husband, for example, you'll need extra forms. The presumed parent and the mother must sign a denial of parentage, and you must sign a VAP with the mother. Only then will your name go on the birth certificate. Option 3 is court-ordered paternity, and that is DNA testing. So what if the other parent won't cooperate? Or you want to be sure before taking on a lifetime of obligations. You will likely need a court-ordered paternity. It'll start with filing a petition to establish parentage. Then you'll need to go to court to get an order for DNA testing at your cost, unless you just do not have the funds and you can prove that. Now, if testing shows that you are a 99.9% probability of parentage, boom, you are the legal father. Now, it's important to note, if you refuse testing after the court orders it, the judge can rule against you by default. Court orders are serious and they are binding. Option 4, administrative paternity order. If child support is involved, the Illinois Department of Healthcare and Family Services can issue an administrative paternity order. No court order is required. And they will investigate and order a DNA test if that is necessary. But be very careful here. This process only covers child support. It does not give you parenting time or decision-making rights. You will still need to go to court to get that. Okay, option number 5, putative father registry. That's a big fancy legal word. If your child might be placed for adoption and you haven't established paternity, you have 30 days from birth to register with the Illinois Putative Father Registry. And that is what protects your rights to be notified if adoption proceedings begin. No registration means that you might lose all rights permanently without even knowing it. And even if you do register, you still need to establish paternity separately. So what happens after paternity is established? Well, once paternity is legally established, this changes everything. You have the right to ask for parenting time, and you can seek shared custody or decision-making with your child. Your child can access your health insurance, Social Security, VA benefits, and inheritance. And you gain standing in future custody or support proceedings. But don't assume anything happens automatically. In Illinois, the law says that mothers have sole custody by default until a court orders otherwise, even if you have been there since birth. We once worked with a father. He signed a VAP at the hospital. Paid support, but when he tried to see his son after a breakup, no dice. Mom would not agree. And he came to us super frustrated saying, I signed everything. I thought I had rights. He didn't, but not yet. We helped him file for parental responsibilities, parenting time, and after a full hearing, he got a parenting schedule that protected his bond with his boy. Paternity opened the door, but he had to walk through it to get his rights. Whether you're a birth parent or a presumed father, 2025 Illinois law now gives more ways than ever to establish paternity. But it is still full of tight deadlines, complicated forms, and critical next steps. And if you're also going through a divorce, your rights as a parent could be also at risk. So in this next video, we'll show you exactly how parents lose custody in an Illinois divorce case and what to do right now to protect yourself.